but it's not, I'm not staying. All right, good morning, everyone. I hope you had a good day yesterday, had a good evening last night, had fun, and are ready to start the day again. Today we're going to talk antitrust, major questions doctrine, media, free speech, and more. I just want to note at the beginning, I know lots of you have flights this afternoon, but remember the Aspen Airport is very close and very small. If you leave here even within an hour of your flight, you'll have plenty of time to sit around at the airport doing nothing. So, don't miss things because you think you have to be at the airport so early. And if you miss your flight, don't blame me. Now, one other thing quickly before we start, there was so much talk about generative AI yesterday and how people integrate it into their workflows or not. I thought it would be interesting to do a poll. So if you go to Slido, I don't know if you can put that up on the board on the screen too. You should be able to see this poll asking how often you use generative AI in your daily work. So please go to that poll and vote if you, and then you'll have a nice little piece of information for the next cocktail party you go to. And we will pretend that this is statistically valid and an actual representation of the US population. So while you're still doing that, let me just set things up for the next panel, which is a conversation with FTC commissioners. We're honored to have them here. So Bill Kovacic will be doing the moderator. He's the Global Competition Professor of Law and Policy and Professor of Law and Director of Competition Law Center at George Washington University. And of course, we're thrilled to have Commissioner Andrew Ferguson from the U.S. Federal Trade Commission and Commissioner Melissa Holyoak, also Commissioner in the FTC. And so I will now just hand it over to Bill.
Scott, thanks to you and to Tom for putting this together and giving us the wonderful privilege of participating. And thank you both, Commissioner, Andrew and Melissa for participating in the conversation. Those of you who follow administrative law, government regulation know that we're in a period of the Supreme Court's rethinking a number of basic propositions about the administrative process. Some of these have dealt very intimately with the FTC's authority. In the AMD case involving the Commission's ability to obtain monetary relief using Section 13B of the Federal Trade Commission Act, the FTC, by a narrow margin of 9-0, lost its fight to preserve that authority in an opinion written by Stephen Breyer, who is the Commission's very best friend on the court at the time. In the Axon case, which dealt with a somewhat more technical issue about the timing of challenges to the constitutionality of the FTC's framework, a case called Axon, the FTC once again by a narrow margin of 9-0 lost in an opinion written by Justice Kagan. Not since 1931 had the FTC appeared before the Supreme Court and gotten shut out. If you ask when has the FTC in 2 consecutive Supreme Court opinions gotten exactly 0 votes, that would be never. That's not a good sign for the future success of the agency standing before the court and an indication of its skepticism. But there's more. Loper casts aside Chevron. Jarchese has some powerful things to say about the administrative adjudication process and how it operates. The Sela Law case earlier, though not directly dealing with the FTC, had some interesting and provocative hints about what it would think about other pillars of the modern administrative state, including Humphrey's executive. An important but C case is the CFB case, dealing with the funding of the CFPB, in which the funding mechanism which gives the CFPB remarkable insulation from congressional oversight in funding and appropriations decisions survived. So an opening question I'd like to ask our commissioners is, to borrow a phrase from Churchill, is the FTC sailing into a gathering storm here? A gathering storm that poses some degree of peril to its basic operations, functioning, and effectiveness. At a high level, is that happening? Andrew, can I begin with you?
Sure. Thanks, Bill, and thanks to the Institute for having me. I'll stay out of the sailing metaphors, and instead I'll say this, and I'm not going to call it a revolution in administrative law. It's sort of like a restoration. I think the majority of the court sees this as restoration rather than revolutionary. And I clerked on the court in OT 16, which was sort of right when this was beginning to mature. In my view, Free Enterprise Fund is like the starting gun to the restoration. It was the court sort of announcing for the first time, we're going to start taking the appointments clause and the removal power a lot more seriously than we had been taking it, and then other stuff started to follow. But of all the things that the court seems to care about in kind of restoring presidential authority over the administrative state and restoring congressional authority over policymaking, it's things like appointment and removal. Well, the FTC has an issue with that. Humphrey's executor was about the FTC. It's about administrative adjudication of private rights. Well, the FTC does that a lot, so that issue also captures the FTC. You know, claims of expertise, I think, you know, in terms of Chevron, the commission doesn't typically invoke Chevron that often to defend its rulemakings, but one of the pillars of Chevron had been about the allocation of expertise within the executive branch and the use of expertise to answer difficult policy questions. And the court has increasingly, and I think in Loper Bright makes very clear where it stands, is starting to express pretty substantial skepticism about admin state claims to expertise. And you know, this was sort of like a bloody shirt that agencies would wave in litigation. You know, you'd get a statutory question and the agency would say, we're the experts, Congress made us the experts, you guys need to defer. And at this point, the court is like, we have substantial sort of like descriptive doubts about your claim to expertise. It is no longer clear to us that a lot of these giant agencies are the experts that they have long claimed and that the administrative state's defenders have long claimed. And B, what expertise do you need to interpret texts of statutes? We're judges. This is literally what we're here to do. You guys aren't shedding any light on this. And so sort of the FTC is, and also, you know, skepticism about invoking sort of highly vague, super general grants of rulemaking authority as the basis to make rules. The FTC has that too. And so all of the things that the courts have started to care about in, you know, what I view as a restoration of the separation of powers and the allocation of power among the various branches, the FTC has. And so I don't know if we're sailing into a storm, but insofar as the court is moving in a particular direction, we're right in the middle of where they're going.
Melissa, do you share the thought that this is, if not too melodramatically, a moment of peril? Is it a moment of instability and perhaps doubt about the direction and effectiveness of the Commission's program?
I think that's a great question. Just to add to what Andrew was talking about with Chevron, we have dozens of statutes. I'll just give you an example of one just recently, a couple months ago. It's called the Healthcare Breach Notification, and we put out a rule. I dissented from that, and the question was how to define healthcare provider. And so the example I gave in my dissent was the rule provided such a broad definition, it would sweep in all kinds of health apps. So for example, a gas station that might sell Band-Aids and aspirin that has a loyalty program, all of a sudden is now a healthcare provider under this. And what I pointed out in my dissent was, look, you have to go back to the statute. Let's look at the statute. And it basically following what Gorsuch said in Loper, which is, please look at the statutory text, look at the linguistic context, look at canons of statutory interpretation, and that's what we're gonna have to do. We're gonna have to show our work. We're gonna have to go in and not just have some reasonable explanation of why our rule looks, can fall within the statute, but that our explanation is the right one, and we can do what we're trying to do. And in that case, I think we are way off in terms of trying to follow this statutory interpretation. And the problem is that when we take such broad, sweeping definitions and we try and do these things, it really undermines our legitimacy. And so going into this storm, we're taking on lots of water. I'll jump into a metaphor. I love jumping into metaphors.
Yeah, he's wrong. That was a good one. Yes. We could have used mountain climbing, something else, but it was a good one. Yes.
We're jumping in the storm. We're taking on tons of water, and we want to go to Congress and get our our AMG authority back or get new authority under privacy. And they're not going to give us buckets to get that water out. They're not going to give us anything. So I think we need to be thinking about that. And the Chevron is going to help us, I think, it's going to force us to become much more disciplined. We can't live in our agency echo chamber of what we think how we should apply the rules.
I thought you were going to go directly to the Muhammad Ali Boxing Act, which is one of the 60 grab bag statutes that the FTC has, not to mention horse racing, the Dolphin Protection Act, and a host of others where Congress, I guess the political science metaphor is it's the trash can metaphor, where do you put it? Give it to them. And there's a lot there. To come back to Chevron and the way that courts look at agency decisions, after Chevron, how does an agency get deference? How does an agency persuade a court that it's got the expertise that Andrew was referring to before? I sat with a group of federal judges once and asking about Chevron, and they said, this is not a recordable conversation, but to us, in many ways, it doesn't matter. You don't demand deference, you earn it. How does the Federal Trade Commission, in perhaps a Skidmore world, but in a pre-Chevron environment today, how does the FTC earn deference when there is some element of interpretation involved? And it's asking the court, take our expertise, our interpretation, we know what we're talking about, how do you earn that deference?
I think there's two answers to that. The first is like Loper-Bright left open the possibility that I think Adrian Vermeule's called this retail Chevron rather than wholesale Chevron. The idea that there are particular organic statutes that command courts to provide or to grant deference to agency resolutions of statutory ambiguities, but not a general sort of superintending administrative law principle. They'll look at a particular organic act and be like, oh, Congress tells us we need to defer to you. I don't know what that looks like. Congress has never written statutes that way. It wasn't writing statutes that way before Chevron because no one knew Chevron was a thing. And after Chevron, it had no reason to write statutes that way because everyone thought Chevron was taking care of this. So I don't know what that's actually going to look like as a formal matter. As an informal matter, look, I mean, the FTC is a big-time repeat player in the federal courts, especially in antitrust cases. You know, in the run-of-the-mine case that the FTC is bringing to, for example, block a merger, you're probably going to wind up with a district judge who's smart and has never considered antitrust law in his or her entire life. I mean, I've spent a fair amount of my career selecting and confirming federal judicial nominees. They're all hardworking and smart, but antitrust is a super narrow slice that's important. But it's very narrow.
You did not put that at the top of the list.
No, we weren't. No, and especially district judges in states outside of the big cities where a lot of the antitrust action tends to happen, just won't have much experience with it. And so when you've got these big billion-dollar mergers, the government saying one thing, the parties saying another, and identically credentialed economists saying the exact opposite things to this judge about the exact same set of data, a judge is going, how am I going to resolve this? This like substantial, it's effectively like an ambiguity about the world. Like we're making a prediction about competitive effects. The government says X, the other side says negative X. The government is a repeat player full of civil servants, has always gotten a little bit of the benefit of the doubt from judges. Judges will go, look, these people are Congress's experts in this area. This is why they're here. They have to come back to the courts all the time. They're not going to try to BS me. I'm going to weigh that a little bit in the balance. There's like a depository of credibility that the agency has with the courts. But when the agency presses like very aggressive theories and then gets shellacked in the courts, that draws down from that deposit of credibility, and you don't replenish it until you get a bunch of wins. And so I think the way that the agency earns this sort of informal form of deference is it brings good cases and it wins those cases, and that gets around. Judges read the Wall Street Journal. They know about stuff happening outside of their little districts. And when the agency keeps taking it on the nose in its cases, courts will start to say, why would I trust these guys when they come in these tough cases that are close? Why would I give them the benefit of the doubt? I'll speak just for me, but I would bet Melissa mostly agrees with me. I see it as part of my role is to protect that deposit of credibility when deciding whether to bring cases. And if we've got a case that I think we probably have a good argument, but I don't think we're going to be able to persuade a district judge, I don't see much point in bringing it because we're just going to draw down on that deposit of credibility. The FTC is going to lose both public and judicial credibility, and we can't restore it until we get wins. So I think the formal answer is I don't know what Loper-Bright deference looks like. The chief didn't say. The concurrences didn't say. I have a hard time, frankly, imagining a statute that would meet what the chief was talking about in Loper-Bright. But the informal deference I'm talking about, you get by picking up wins. And I think the agency has taken a couple on the nose for the last 4 years, and it needs to replenish that deposit.
Yeah, I had a conversation with a member of the Supreme Court and a member of the D.C. Circuit, and I asked them, do agencies have brands when they appear before you? Do they have reputations? And they looked at me and simultaneously said, hell yes. How long have you lived in Washington? They said, of course they do, and that either gives you a halo when you walk in the room or a negative halo. Melissa, Andrew talked about how you have to give them confidence. What do you do in using all of your policy-making tools? You mentioned showing your work, but how do you show that we bring these to bear on these issues and we know what we're talking about and you should listen to us?
Great question. And I'd say just in addition to judicial deference, just deference or to create that credibility, not just with courts, but with Congress, with the public, we need to have good, sound economic analysis, and we need to have empirical work. That's why we have an independent Bureau of Economics. And one of our greatest tools that we've used in the past is our 6B studies that we can bring in. We have our expertise. We collect non-public information. We look at it. We're experts. We put together really fulsome reports. What I am concerned with, and just a couple of weeks ago, I issued a dissent on this. We issued an interim report on PBMs, and unlike our past work, which was fulsome, there was a 2005 report on PBMs that was fulsome, was empirical, was economic-based. This report was not. And that was what my dissent laid out. I'm very concerned that we have these predetermined conclusions, the sound bites that we want for our press release, and then we come in and fill in the details with a report. And that's not how we should be doing things. It undermines our credibility, not just with courts, but with Congress, with the public, with markets, with private parties on how we're approaching these issues. I think that we're not a sunk ship. We can come back, we can write the path. But that's why I pointed this out. And I do think that we will be able to finish that report and get the work done. But it needs to get done if we're going to have the confidence of the public.
I mean, when you look at the original design for the commission in 1914, this 6B study authority was going to be a crucial tool to providing the empirical foundation for making good judgments about policy, and to draw that in a way that convinced courts. And I think the reputational effect is not just at home, it's abroad. Other institutions around the world read these. These are powerful soft power tools to be used. That was an important way to use this. And I shared your concern in looking at the PBM study. It identifies the author simply as being the Office of Policy Planning. You look at earlier FTC studies and you ask, do these people have names? And what you had in the earlier practice is all their names are there. It identifies the people who worked on it, the main contributors. It was both a matter of pride in giving acknowledgement to them, but also accountability. That is, these are the people, not just an ill-defined Office of Policy Planning. I did not see that as a way to create, again, the aura of expertise that would be successful in the future. And I think you were right on target in raising questions about that. Can we come back to Humphrey for a moment? if it is teetering, and there certainly are signs that it is, does it go? That is, if we have this conversation in 5 years, is it still there? And if it goes, does it matter? Andrew.
I think it's gone. I think Justice Thomas is right that there's basically nothing left after SELA law. And I don't think it matters all that much because the ultimate check on the president's appointment and removal has always been political. If the president, decides to decapitate an agency by removing all of its leadership, he or she will have to suffer the political consequences of that, and that's the ultimate check. Is if a president wants to ruin an agency or stop its work, it has to answer to Congress, and it's not like Congress has to just take it. We're not used to this now because of the current state that Congress is in, but Congress used to act collectively to defend its prerogatives against the executive branch all the time. And it would threaten funding for stuff unrelated to whatever the fight was about as a form of leverage to compel the president to heel. And this was super common. So, for my own part, I operate under the assumption that the president probably can fire me. I'm not saying that if I weren't fired, I wouldn't, try to do Humphrey's round 2. But I see as the sort of the ultimate check, the same check that every other officer operates under, which is, I'm an officer of the United States in the executive branch. The FTC's arrangement within the executive branch is a little unique because it has to have Republican commissioners even if there's a Democrat president.
There's a political diversification.
That's right, and at least some scholars have questioned the qualifications requirements for as a violation of the president's appointment power, but most think they're okay. And if the president, decides to just fire the Republican commissioners as Republicans, A, he still has to appoint Republicans to replace them, and B, has to suffer the political consequences. And look, I don't think the agency fared well publicly for the more than a year that it had only Democrat commissioners. It undermined its credibility. Congress was constantly criticizing the FTC as basically a single party servant of the Democrat Party. And it wasn't good for the agency. And I think, especially if you polled the staff, for example, they love having Republican commissioners. They love the fact that there's some diversity of thought. They love the fact there are people who push back on some of the more aggressive theories. I've written 15 statements since I joined the commission, and most of them have been either dissents or concurrences that were basically dissents. And I did 2 this week. And I think that's sort of how the commission is supposed to operate. But at least for my part, I operate under the assumption that the president will fire me if I do something that he thinks is truly fireable. And I operate under that assumption because I think the writing has been on the wall for some time that if they get Humphrey's executor back, they're going to say, Congress cannot interpose itself between the president and his principal officers. The executive branch can't function if Congress is constantly shielding people who are supposed to answer directly to the president, which Melissa and I technically do, from his control. That's how you get a freewheeling, independent bureaucracy that ends up answering to nobody.
Yeah, when I was chair, I thought that 5 commissioners was 4 too many on many days.
You're not the only chair that thinks that, I think.
They tend to think that, and at the same time, if you're a mere commissioner, you always think you'd be a better chair than the chair. That happens all the time, but that's all right. You don't have to remark on that, but that's how I felt.
You wanted to change the name to the Federal Trade Chair?
That's right,
That's
right. With advisors, they could be extended advisors. Glad to hear your views right in the trash. Here we go. Does Humphrey matter to you, Melissa? Do you think that if it disappears, that it affects the way that you and others would approach your job?
No, I don't think it would. I think for all the reasons that Andrew was talking about, I don't think it would. I also think I agree with the courts. There's a healthy bit of skepticism for these independent agencies. It's really difficult to sort of to accept that with our system of government, with our Constitution. There are not 4 branches of government, and so it is difficult because of the democratic accountability and democratic principles to have this separate independent agencies. I think from my role and my perspective, I do think that tension can be relieved in some bit by by following closely to the statutes that authorize our actions, that if we hew closely to those, that we are actually making sure that we are following what Congress intended us to do. And in particular, making sure, I think a good example of that is not just in our rulemaking and adjudications, but thinking about this sub-regulatory guidance that is coming out from the agency. That scares me a lot, because that is where you have all of it's like triple insulation in some of these respects. And so I'm paying close attention to ensure that that kind of sub-regulatory guidance is also doesn't get out of hand.
Yeah, Barron points out that the statute says no more than 3 from one political party. So it means you can pick people from other parties. People are so-called independents. In the modern custom, you do have to get those through the minority party, basically in the Senate. So they have some view about who's going to be acceptable there.
Yeah, and just one more thing on this. Lawyers have a tendency to think very abstractly about stuff like this, like, oh, if Humphrey's executor goes, the president can just start firing everyone. That is not how this country works. The president, if he fires people, is going to have to go to the Senate and get the Senate to sign off on his new nominees. And I worked in the Senate for a fair amount of time, doing a lot of nominee stuff, including refusing to sign off on nominees. It's hard. It's very hard. And if the president is spending tremendous political capital on trying to defy Humphrey's executor, for my own, speaking only for myself, I think that would be great. I think Humphrey's executor has been very bad for the government. But if the president wants to do that, he then has to go to the Senate, whose power he's just defied, and ask them to fill the seats with the people he or she would like to appoint. That's very difficult. And so the general response of defenders of Humphrey's executor, which is like pandemonium, the president, canning dozens of people overnight, I think, I'm not sure that would be the worst thing of all time for the president to sort of assert control over the bureaucracy since he's answerable to the people. I'm not sure that'd be a bad thing. It's just also totally unrealistic. It's not how politics in the United States has ever worked.
Isn't some amount of autonomy, though, in the decision to prosecute really important in this respect? We talked about deference before. You're standing before the court and you're saying, we bring together the full power of our expertise and analysis. It's integrated into our decision. If it appears as though the decision to prosecute was the result of having a gun at the head, you're going to bring this case and do it because I want to punish an enemy, the court really won't defer to extortion. They're going to defer to deference. Isn't it important to have some element of autonomy that the agency can point to say, in doing things that really hurt, we made up our own minds on this?
Well, I'm not so sure. And I say that only because that's how the Department of Justice works, and they continue to work well. And I think because when we're bringing these cases, we want to be successful. We want to win in court. We think about all of those things. There is some, also political ramifications to doing that as well. And so I do think those pressures are going to point us in the right direction.
But if you're right, Bill, and I think that's not a bad. I mean, look, like I litigated AT&T Time Warner. I'm not the only person in this room that litigated AT&T Time Warner.
How'd that turn out?
Well, we won.
Yep.
I'll leave what happened after that to the companies. Yep. But one of the things we tried to make a big deal of was the president said lots of very nasty things about CNN,
sure,
and then invoked antitrust as a way to punish CNN. You should, judge, take that into account. We didn't win the discriminatory prosecution motion, but we at least got it into the water. But I think the point is, even if you're right that independence, the appearance of sort of an independent prosecutorial decision matters to the courts, that's in the president's interest too. Because the president doesn't want to march his agencies off to court to get them shellacked and have a court say, I am not allowing this prosecution to go forward because I think the president is manipulating things behind the scenes. So the president then has an equal incentive to promote this appearance of independence. What I think we don't want is parts of the government that are actually independent from the president, who is the only person in the 4 million person branch of government that answers to the people. I don't, Melissa doesn't, you didn't when you were chair. The only way that people constrain the executive branch is by electing the president. And if people are allowed to do things and he can't have a say in it, that's just not good for government.
Of course, I'd attack an assumption in my own question to both of you about whether agencies today with Humphreys are indeed independent. I've never thought that an agency that had to beg for money every year in front of the Congress was independent. Nor did I think that the president's ability to sign a document that says, Mr. Chair, Mr. Ferguson, you're now a commissioner. Holyoak, you're now the chair. I always saw that as a pressure point that mattered.
Well, if you read the legislative history of the FTC Act, Congress loved the idea that the president wouldn't control them and Congress would. Congress was like, we will oversee them and we will control their budgets, and that means we're in charge of this agency, not the president. I think that design is terrible. That's a terrible way to run the government, but like this was quite intentional.
I don't know if both of you got this question, but I did before the Senate Commerce Committee. Mr. Kovacic, you understand, don't you, that you are an arm of Congress? The correct answer to that question is, yes, I do, Senator, with great clarity. The wrong answer is, no, I'm not. I'm independent. And once you approve this, I get to do what I want, and you can't remove me, and neither can the president. That was the wrong answer. For that, you get sent outside to think about it for a while and come back in. So that wasn't the right answer.
And the right answer was, yes, Senator, I'm happy to come back anytime you would like.
Anytime. And I look forward to continuing the
Yes.
conversation.
There you go.
But, there have been a couple of questions that have raised, I thought maybe a comment on earlier cases that the commission's decided and have made their way through the administrative process successfully to the Supreme Court. One of them that stands out is Cement Institute, and it stands out to me in a couple of ways, is that one, after the Supreme Court basically took Melissa's framework and said, you guys did everything right. You did the studies, you did earlier cases, you incrementally built a foundation, you wrote a really good opinion, and this is precisely the kind of thing we expected the Federal Trade Commission to do in extending the boundaries for Section 5. Bravo, good job. Within 2 years, Congress had extracted a promise from the Federal Trade Commission that said, you will never invoke Cement Institute or the triangle case that went with it. You will never invoke these before as a basis for challenging non-collusive, independent, but parallel conduct. You won't do it, or we'll turn that place into the biggest three-sided swimming pool in the city. And the commission promised, no, we won't do it. It came back to bite it later on. So that the oversight, that is the constraint on the discretion, comes from both ends of the avenue. Mm-hmm. I think a dilemma for the commission is that when it does things that push the boundaries, you're either going to get the feedback loop through Congress that says, don't do this, it's something new. Well, yeah, you told us to do new things. Mm-hmm. Or there are constraints from the executive branch. Goes in both directions. One last question about, and it's contained in some of the, suggested in some of the questions here, which is an issue raised yesterday about the flexibility and adaptability of a regulatory system, that it should be agile, it should be flexible in dealing with artificial intelligence, other new developments, that the second you'd write a statute, even if it was highly specified, you'd have the same problem you'd have in trying to write a highly specified contract. It would always be incomplete. There would always be gaps. You can't write the perfectly specified contract. So you try to write it. How do you write a statute that says we want agility, we want flexibility, we know you're going to have to be changing the boundaries over time? If that's a desirable approach for public policy making, how do you write that in a way, and perhaps say, Federal Trade Commission, you implement it? How do you write a statute that has those elements of adaptability and flexibility built into them, but necessarily involve interpretation and adaptation in a way that avoids major questions and avoids a delegation problem? How do you do that?
I don't know. Look, I mean, I in my admittedly overlong non-compete dissent, half of it was about non-delegation. And I mean, look, I, for my own part, as a commissioner, take very seriously that the principal policymaking branch of the federal government is Congress. And that it needs to be that way because Melissa and I do not have a constituency. We are, most of us are ensconced within the Beltway, disconnected from the people we're governing. We don't answer to them. They can't control us. If we get it wrong, all we hear about it are in lawsuits. And for that reason alone, along with a bunch of other formal constitutional reasons, it is super important in my view that Congress decide what conduct is prohibited, what conduct is required, and the agencies enforce those prohibitions and those mandates and fill in small gaps. I think I mean, it was obvious as early as Schechter Poultry, because the court has a long discussion about the non-delegation problem inherent in Section 5, that there are significant constitutional limits on how flexible Congress can write its laws because of the importance in a self-governing society of accountability between the people who decide what conduct is prohibited and what is required and those who are compelled to obey those restrictions. And so I think sort of the height of progressive New Deal era governance, which is we write general ideas into statutes, we appoint these experts who will all live inside of 495 in Washington and set the rules for the country. The courts, they're not there anymore. And they were there in the 30s and 40s and 50s, 60s and 70s and 80s. They started to not get there in the 90s. And I think largely thanks to President Trump and Leader McConnell, the courts are just not down for this sort of progressive view of government, which is Congress comes up with ideas and then the president decides how to implement them on the ground. So I think that the boundaries within which you can write flexible statutes when they were doing this sort of beginning in 1914 and onward have narrowed in just the last 20 years. For my own part, I think that's a good thing because I think that those boundaries implement values of self-government, which I think are the ultimate constitutional values, or that we govern ourselves. And I think that that is less true when bureaucrats like me are deciding what conduct is required and what conduct is prohibited. So I don't know how to write those statutes, and I think it has gotten harder just in the last 15 years.
I think that's right.
Please.
I think Section 5, though, has been, I think, a good example of something that's been flexible and has provided some guardrails in terms of going after unfair acts and practices that harm consumers, that consumers can avoid, that with countervailing benefits, like that balancing test. And that flexibility can be applied, we have seen even just recently, to artificial intelligence. Our Consumer Protection Bureau has filed complaints related to artificial intelligence, mostly just deceptive practices relating to marketing, telling folks, hey, my product has artificial intelligence in it when it doesn't, things like that. So it can adapt. It probably can't conquer the world and can't do everything. So the Congress does have to go in and think about many different things and try and craft that same type of flexibility to other areas. And it's difficult. I don't know how they do. It's really hard. And I think they're going to struggle with that. I think when we'll see how they do that with privacy, data security. I know that they're trying to grapple with that right now.
Let me ask, we've got about a little more than 5 minutes left. A question. We've been talking about things that are a bit hazardous, a bit difficult. What do you see to be the high ground? Melissa, if I could start with you. That is, what should be the priorities? What do you see that is not currently on the agenda? What would you like to see the focus of the agency be going ahead?
I mean, priority number one absolutely has to be protecting consumers. Absolutely. Our antitrust enforcement has to look at competitive effects and consumer harm. That is the lodestar of antitrust enforcement. It has always been, has to remain there. What I don't want to see is efforts where there is we're going after trying to attack antitrust or enforcement where that does not exist, and we should not be doing that. As an enforcement agency, it's always difficult to determine where resources go. It is a constant balance. We want to look at where's the greatest consumer harm. You want to look at the resources to actually try and redress that. You need to look at what will it take to, in terms of resources, not just man hours, but experts and the likelihood of success in all of that. And that, trying to weigh all of those factors and make a determination, it's very difficult. But I would want to focus all of our bulk of our efforts on where we know that there's greatest consumer harm, and in antitrust, it's more often than not going to be horizontal unilateral effects that are where we see the greatest consumer harm. In consumer protection, it's going to be fraud, and it's going to be for the most vulnerable, which I think children, elderly, some of those other populations. that's where I would focus our efforts. That's what we do best, and that's where I think the FTC should remain focused.
Andrew, what do you think's the high ground? What would you put on the list of priorities to be pursued?
There's been a lot of talk, like 6 years now, that the current antitrust laws are insufficient to confront the novelty of big tech. I have some skepticism about that, and I think that there's a lot of work that sections 1 and 2 and 7, even under like current understandings of the law, could be doing that simply wasn't being done. I mean, we did this in the States. We brought a big Section 2 suit with the United States against Google for its ad tech monopoly. Melissa brought a similar one like a year before Virginia did. It wasn't a novel theory. It wasn't trying to expand the boundaries of Section 2. It was just sort of doing work that people had generally not wanted to do for a variety of reasons that I won't get into, basically a variety of prudential and political reasons. But I think look, I want very vigorous antitrust enforcement. I think that the antitrust laws have gone under-enforced generally for the last 10 years, but I don't want to throw the baby out with the bathwater. I think there's a ton of work that traditional antitrust could be doing that wasn't being done, and I think before the agencies and the president are going to Congress and asking for a new suite of antitrust laws or a new suite of consumer protection laws, I think we have to actually exhaust the boundaries of existing law, which we have not done. And so I want to, I want vigorous antitrust enforcement, and I think that there's a ton of work that both parties just weren't doing and can do under existing law, particularly with regard to sort of the novel business practices of large technology firms that can be done. And I don't think we necessarily need to be clamoring for a revolution in antitrust law to address a lot of the concerns that consumers have about a lot of these companies.
Maybe a closing question for you, and then we'll take a few more questions, maybe from the audience here. A big theme of the discussion yesterday was the fragmentation of policymaking in a number of policy domains. We have, as you know, 2 federal agencies with a shared mandate for competition law, not exactly equivalent, but largely overlapping. We have state governments that also have antitrust enforcement authority for their own state laws and for the federal laws. And by the way, with your presence on the board, it's the first time that the Federal Trade Commission has had 2 individuals who have served in such senior levels of policymaking within their state governments. So we have a uniquely deep perspective from the states represented on the commission. We've never had that before, and it's glorious 115-year history or so. What can be done to improve coordination among them? There was a call for some process to achieve a greater sense of consensus about the direction of policy, setting priorities, maybe planning how resources might be allocated, but to achieve what other jurisdictions have, the European Competition Network, and the UK, the United Kingdom Competition Network. Do you have thoughts about what could be done to realize the possibilities of better performance, joining up some of these institutions, maybe to avoid unnecessary conflicts, to improve coordination, to improve performance? What might be done?
It's a great question. When I was with Utah as a state enforcer, we participate in a lot of multi-state actions. And there's great benefit to that, to have many states together, to pool the resources, to bring on different attorneys, and just even financially to be able to share the costs of all of that. It can be very difficult, though, too, because you really have 50 different sovereigns, or 50 plus, who are trying to make decisions, and to bring everyone together, it comes with its own difficulties and complexities in terms of getting that done. When I was with the state, I also worked with the FTC oftentimes. Those would mostly come with respect to merger reviews that were happening in the state, and we would coordinate with them. Those have their own challenges as well, in terms of the FTC wanting to pursue some things that maybe we didn't agree with. And we'll see. I see that now on the other side. I'm like, no, we want to work with you. So it's difficult. You've seen it from both perspectives. in terms of working together better, I think there could be some better coordination. I think, as Andrew and I have seen, oftentimes these multi-states, they come together because these are my best friends, these other states, and this is who I want to be litigating with for the moment. And so it's not as if it's always open to every state to join for those very reasons, because it can be difficult to sort of to pursue litigation and have that. And so I think there could be probably some greater coordination among the states in terms of opening it up to others. And with the FTC, probably, I think some coordination can come with just even more regular meetings to understand what the states are thinking of, what the FTC is thinking about, and being able to pool resources and go after these things together.
Andrew, thoughts about how to deal with the fragmentation issue?
I do not think, so I totally agree with everything Melissa said. That was a very accurate accounting of how state stuff works. I'm not sure that I share the drive for a centralizing regulatory power. I'm not sure the fragmentation is bad, and frankly, looking at rates of innovation in Europe and rates of innovation in the United States, I'm not sure the European model of governance is great for America. I love that America continues to innovate, that new companies are popping up all the time, that a huge swath of our top market cap companies are quite recently created. And I think that is in no small part to the fact that we fragmented regulatory power outside of the federal government into the states, that there isn't always perfect coordination, and it leaves gaps. And I think there's a fair amount of innovation that takes place in those gaps. And sort of the European bureaucratic drive for centralized, highly rationalized, superintending regulatory power, I'm not sure it's great for America. So I am not sure that the fragmentation, which is undoubtedly part of the constitutional design, should be treated as a fault rather than a feature.
So that if you have a retail merger and you've got one federal case going, you have two state cases running in state court, there's no upward bound on the right number of cases?
Yeah,
that merger?
There probably are, but my preference would be for regulatory fragmentation, because I think if we drive for centralizing control, it just means control in Washington, and I don't think that's good for innovation. And I don't think that's, innovation is, the American spirit is sort of what drives our incredible innovating impulse, and I think Washington-controlled, centralized regulatory authority is not good for that.
Let's take two questions from the audience, and then, let's see. Please.
I would ask, the coordination among the states makes complete sense, but where did the mandate come from for the FTC to travel to Europe and assist those regulators in attacking American companies with transactions that largely occur on this continent? Is that the kind of coordination that you would envision? Thank you.
I think with respect to foreign policy, that is absolutely within the purview of the executive, and we should be following the president's lead on that. I don't think that we should be undermining American markets, American institutions by going abroad and saying, you know what, this case wouldn't work in the United States, maybe you should bring it. I absolutely don't believe that we should.
So
do
DOJ
that.
could do that. Not the commission. Please, Andrew.
I'm going to give the answer that I gave in an interview to basically the same question, which is markets are global. A huge number of American companies participate in global markets. Working with our colleagues in foreign countries to try to figure out market effects, totally appropriate. Asking foreign regulatory authority on the sly to do our dirty work when we don't think we can do it, wildly inappropriate. Terrible for American companies, terrible for innovation. Look, working with our foreign colleagues, it's an absolute necessity in the 21st century. Having them do the stuff we don't think we can get away with, outrageous.
Absolutely agree.
Maybe not dirty work, maybe God's work in some instances. But take one more, please.
Oh, Scott, we had a question here first. Yes.
I'm going to actually give the mic over to Harold. He had some great questions in Slido.
Harold.
Hi. Yeah. Wow. And looking forward to our panel on admin law. I just have to ask about one thing in particular, which is this notion that agencies have brands, that judges make decisions on whether there's... How is that not the opposite of the rule of law of judging each case on its merits? Even if you think an agency generally doesn't do a good job, the notion that you're just going to ignore their findings. I mean, if we said in a criminal case, yeah, this guy's a convict. I mean, we just know he's guilty. We don't have to worry about a specific, how do you reconcile this concept of not treating an individual agency decision as an individual agency decision where you seriously dig into the work of staff to determine its level of expertise with this notion of, well, we just don't like a particular agency because we think they're all over the place?
We'll close with that. Melissa, then Andrew.
I don't disagree with you in terms of the rule of law. The judge should take all of what's happening, should take the case as it is and look at that. I think the judges, though, if they see that a novel theory come before them and can see that those other novel theories in other courts have been rejected, that's going to play into their decision making. But also, it's not that brand doesn't just, I think, affect the courts. I think it affects everything. I think it impacts Congress and how they view what we're doing, whether there's legitimacy, whether we should be provided additional resources, funding, authority. It impacts markets and private parties, how they perceive things, whether there's certainty, which I think that they deserve in the markets to be able to run their businesses.
Andrew.
I think that's like a straw man version of what we were saying, with all due respect. I mean, I don't know any judge who would look at the caption and be like, oh man, the FTC, they're definitely going to lose. I think what happens is the FTC and a super sophisticated party represented by exceptionally talented lawyers are disagreeing on some very complicated question. And the judge is going, gosh, how should I resolve this? This is really, really hard. On the one hand, I have these lawyers from wherever, representing these whoever, saying the FTC is totally wrong. And on the other hand, I have the FTC saying, no, you're right, you should trust our expertise. But I look at these other courts and they're not trusting the agency's expertise. I'm not sure that I should on this complex, difficult question either. And that's totally, A, that's totally normal. B, anyone who's ever had to litigate an APA case, and I've litigated a lot, knows that's exactly how this goes. These often resort or are reduced to some very complicated factual question in which the agency doesn't have the greatest statutory argument but is waving around its expertise. If the agency's reputation is very good, it has a stronger claim to expertise than if its reputation is very bad. And that is how all litigation in the APA, outside the APA works. If someone comes in with a reputation in the judiciary for not getting it right, that will affect judicial decision-making in close and difficult questions, especially, as is true in most FTC cases, when the other side is super sophisticated and has very good lawyers.
My only gloss on what my fellow commissioners have had to say is that there are so many instances in which you're ultimately asking the court to trust your good judgment. You have difficult, problematic issues that, say, in mergers involve difficult predictions about the future. In tech matters that involve abuse of dominance, if you're talking about remedies, what's going to work, what might not work. In many ways, you're putting your accumulated experience on the table before the courts and saying, this is our interpretation of what's happened. And with respect to uncertainties about the future, this is our best judgment about them, and you can trust us.
Yep.
And I don't see that as being a transgression of the rule of law. I see it as giving judges confidence that your judgment about the future is a sound one. And in that respect, yes, agencies do have brands. They have reputations. And in that respect, a judge might say, I'm affected by what you've done in earlier cases.
Well, does it work in reverse? I mean, everything that Judge Leon laughed at in AT&T merger came true. Prices did go up, people got fired, all of these other... Do judges then have a responsibility to look back and say, hey, we doubted the agency, but the agency prediction that we laughed at turned out to be totally right.
The obligation, I think, exists is for there to be a rigorous program of ex post evaluation.
Yes.
Where agencies look at past experience, where academic hubs do, and come back to courts and say, in case you're interested, your prediction about the future was precisely dead wrong. And in future cases to say, this is why, because we do these ex post assessments, you can trust us, when we advise you about what to do about the next
And in a
case.
similarly situated future vertical merger cases, the government will make that argument. They will be like, we were right about AT&T and the other side was wrong. That should count into your analysis of our predictions of the future. That's how, this is so commonplace in litigation, I don't know how to like explain it more. This is how it always goes, always.
And I think the commission marshaled those arguments very well in Illumina, which is a case if you were going to a betting shop about what was going to happen in the Fifth Circuit, you'd say, I bet on Illumina all the way, and they lost. They got skunked across the board on all the arguments. I think that's an instance in which the commission was able to marshal this expertise in saying, we know what we're talking about, you can trust us here. Well, join me in thanking our panelists. And by the way, don't go away, there's a great panel coming up. Thank you.
Thank you, Bill.